We had like 40 something people that were registered for today, like 44. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation. My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. We are here today to talk about wills and advanced legal planning and how to draft your own will and transfer on death deed. But also included in our partnership, we have the City of Houston's Department of Neighborhoods, and joining us representing them, we have Ms. Cecile Carlson. Also, on behalf of our presenting partner today with Lone Star Legal Aid, we have Ms. Jessie Campbell, who's going to be presenting all the information that you all need today about drafting your own wills and TODD or transfer on death deed. But also included in our partnership, we have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, the Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And basically, what a month of service is the collaboration of all 8 of our organizations. We come together on a monthly basis and offer a variety of different workshops, resources, and information to the community about asset protection, asset building, community empowerment, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there that don't have access to a lot of information, a lot of accurate information. There's a lot of misinformation that's kind of out there that people kind of get a hold of, and a lot of stuff kind of floating around on social media that's not relative to the state of Texas. And we kind of want to dispel some of those myths and make sure that people actually have accurate information that can actually protect their generational wealth. So again, we several years ago we started collaborating, coming together, and offering these presentations. We were in person, but of course, due to COVID, we had to adjust and adapt to the virtual platform, which has actually allowed us the opportunity to reach people, well outside the city, the surrounding counties, and across the state of Texas as well. Um, so do know that information that does get presented here today and for all of our workshops is relative to the entire state of Texas. It's not just for the city of Houston or for Harris County. So do know that wherever you're joining us from, that it is relative to your area, the laws as well. Also do note that the information that we do present here today is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid if you do find yourselves in need of any civil legal assistance to apply for their services. Do not automatically discount yourself and assume that you will not qualify. So we do encourage you to reach out. This is your opportunity to ask questions. We do have the legal expert that's going to be providing the information for you today that you can ask questions of. If you're joining us on Zoom, please feel free to type your question into the chat. Also note that we are recording the session as well as broadcasting live on our social media platforms on YouTube and sharing on Instagram and on Facebook. So please, as you're asking your questions, we do ask that you try to keep your questions to be as general as you can so that your personal detail information isn't getting out there and we can try to protect your privacy as best as we can. So do keep that in mind. If you are joining us on social media, please feel free to type your question into the chat. I will be monitoring, I'm sorry, in the comment section. I will be monitoring the social media so that I can translate or have your question addressed to Ms. Campbell at the end of the presentation. Or again, if you're joining us on Zoom, please feel free to either type your question in the chat or, you can raise your hand or unmute yourself at the end of the presentation and we will answer your question from there as well. So with that being said, we're going to go ahead and get started because there's a lot of information to cover today. And we're going to go ahead and get started. So Cecile, why don't we have you introduce yourself? Cecile, can you guys hear me okay? You're Cecile, you're on mute. How about you, Jesse? Can you unmute yourself?
Yes, I can go ahead. Yeah.
Cecile, you can't. Did we lose you? What?
Okay. All right.
Okay, so we'll have Cecile put her information into the chat, and hopefully at the end or sometime we can have her come in and introduce herself and tell us about the Department of Neighborhoods and what they've got coming up. So
Okay.
is that okay, Cecile? You want to wave yes, no, or okay? All
Can
right.
you guys hear me now?
Yes.
Oh
Oh,
yeah.
I'm so
Okay,
sorry.
got it.
My screen froze. So sorry. My screen
It's,
froze. Hi,
you
good
know,
afternoon, everybody. My name is Cecile Carlson. I am with the Department of Neighborhoods, and on behalf of the Department of Neighborhoods in the city of Houston, we want to welcome you and thank you guys for spending another afternoon with us. Thank you so much to Jesse as well and Lone Star Legal Aid for bringing the information to the community. And without taking up any more time, I'll pass it on to Jesse. Thank you guys so much.
All right. Thank you, everyone. My name is Jessie Campbell. I am a supervising attorney with Lone Star Legal Aid, and I work out of our pro bono office, which works with members of the private bar who volunteer their time to provide free legal services to our qualified applicants. Today, I am going to be presenting on how to draft your own will and a transfer on death deed. But first, let's talk a little bit about who Lone Star Legal Aid is. So we are a civil legal aid service. We provide free legal services to eligible households that is based on financial eligibility on a variety of civil legal needs. That includes consumer, employment, family health, housing, landlord tenant, juvenile issues, neighborhood problems, estate planning, and probate, which is what I'm here to talk about today. We serve 72 counties in the eastern third of the state of Texas, plus 4 counties in the Texarkana area of Arkansas. So we have 14 offices in addition to our headquarters in Houston, which is where I am located. We have 13 branch offices throughout our service area. And typically what I say is that if you may or may not qualify for services, but if you believe you are and you need legal assistance, feel free to apply for services and of course share information with those who may need some assistance. Okay. All right. This is Miss Nia already mentioned, but it's always worth repeating multiple times from the lawyer perspective. Today's presentation is for educational purposes only. Today is not a substitution for advice. I'm here to provide you as much information as I can about how to draft your own documents so that way you are informed, so that way you know what your next best step should be as you think about whether or not you need to seek an assistance of an attorney to help you draft your documents, to help review whatever you do and things along that line. So there's no substitution for advice today. Also be aware I cannot advise you today. I am restricted in that I can only serve individuals who are eligible for services. So if you do ask me a question that rises up to the level of advice as opposed to information, I cannot answer those questions. And I'm just telling you that right up front. Don't think I'm being mean when I'm like, sorry, I can't answer that question. I am restricted from that. If you do need individual assistance, please feel free to give us a call or apply online, and then I will be able to help you further at that point in time. But otherwise, just kind of be aware of that. This is forever. We are on the internet. Not only for those of you who are in the Zoom, this is a public space within the Zoom, but those of you who are watching via our YouTube channel or our Facebook channel live streams, the internet's forever. Please do not put any private information in the comments, and particularly anything that people can use against you. Unfortunately, I wish we could believe that every person in the world is a wonderful and good person, but there are bad actors out there, and we don't want you to put yourself in a situation where you can inadvertently cause harm to yourself by some of these bad actors who get this information. All right. But after that, let's get going. So today's agenda is that we're going to be kind of talking about some introductions, right? So how to choose your representative. Then we're going to talk about last wills and testament transfer on death deeds. And then very briefly, we'll talk about the remaining documents that are part of the estate planning packet. Now, the thing to think about is that this is a part two. We actually do a 2-part series. Part one was last month in April, where I talked about an introduction into advanced planning, what it is, why you need it, the things you need to think about, the yellow flags and red flags as you move forward. If you did not have a chance to watch that, we do have that recorded. It is going, so you can go to our YouTube channel and watch it there after you watch this one, so that you can get the more broad information that is supplemental to what we're going to be talking about today. So this is part 2. Today, we're going to get more into the weeds. Today, we're going to be talking about drafting the document, specifically what you should be thinking about as you write them when you use these documents that have been developed by representatives in the state of Texas to help you do things yourself. So that's what we're going to be focused on today. There is a third part in this series, if you wish to call that. So my 2, the one in April and the one today, this is about the before planning. We are planning estate planning. We are planning before a person passes away, and what do we need to do in anticipation for that, as well as planning for incapacity. That's the combination of the 2. There is a third in the series, which is to talk about what happens after a person passes away. That does an overview of the probate process, which is the court process after a person passes away, when we have to admit the will to a court, or how to clear title and alternatives to the probate process. So that's the after part. Someone has now passed, and now we need to know what to do next. I will not be answering questions about the after part because it is a distinctive part. That presentation is done by my friend and colleague next week, and then Miss Nia will send you the calendar with that information. So if you are here because you have questions about, well, I'm an executor or someone has passed and I don't know what to do, please plan to attend that session to be able to get those answers for you. All right. So, but otherwise, let's go. So choosing your representative. For each document, you are selecting a person who will be acting on your behalf. Now, today, the document we'll be talking about is your will. That person is called the executor, and they're going to be the person responsible for what is known as administering your will. And so what they basically do is that they're the ones that will go to court. They're the ones who will work with the attorney and the judge and do all of the paperwork, basically. They're going to draft any deeds that need to be drafted. They're going to settle any debt, pay off debt. They may or may not be the same person who handles funeral arrangements, but that could be the same person, right? And so they're basically stepping into your shoes to take care of your final affairs. That is what the role of the executor is. And that's varied. What specifically they will have to do will depend on what's in your estate. The estate is the property and the debt that exists at the time of the passing. And it's going to be different. It's going to be different for everybody, depending on what was written, how the property is being distributed, what kind of debt we have. And so it can be ranging. And so one of the first takeaways that I always want to make sure people know when they're in one of my presentations is that please inform your executor that they have to do something. When a person passes away, the executor needs to go talk to an attorney. That's the do something. Go talk to an attorney. Bring the will so that way an attorney can review the estate, review the will, see what needs to be done, and then make the appropriate advice on what the next steps would be. And it's, I do a lot. I'm a lawyer. I am not here to try to say that you need lawyers in every situation, although I think that it's very valuable when you can have access to an attorney to help you to go through your situations. You should attempt to get one. And for the most part, we're here to help you. But in the case of a probate and what happens after the fact, you do need an attorney, at least for that initial consultation, to be able to tell you what to do next. That is a thing in the state of Texas. But when you're thinking about who you're going to choose as that executor, you're going to want someone you know and trust who will do what's in your best interest or what you would do, right? So because they're stepping into your shoes, they're taking care of the final affairs. And so you want them to be someone that you know are going to do exactly what you ask them to do, that's not going to put their own personal gains over the heirs because they don't like the heirs. You got to really think about that kind of stuff. I mean, it'd be, some of the things that I do share in these presentations is some of the issues that we run into. So that way you can try to think about it to avoid these problems in going forward, right? And so, if this is an emotional decision sometimes, picking the executor, but like one of the problems that we do encounter is an executor who chooses not to move forward. They're not the primary beneficiary of the estate. They're estranged from the heir. There's a conflict between them and the heir, and they don't care about the heir. And so then they don't move forward. And now the heir is in limbo and they're not able to get the property, and they don't have a copy of the original will. They're not able to move forward, and now they're kind of stuck, and they're paying for property taxes that they may not have to be paying. They can't own the car that they need to get access to. And so you want to be sure that it's someone that you trust. And so a lot of people will want to choose what are quote unquote natural choices, like their children and things. But I'm going to let you know, we had a situation where the person who passed was estranged from their child, and the grandchild was the heir, and there was a reconciliation prior to passing, and so that child was named the executor, but the estrangement still continued between the child and their child, the grandchild. And then now we were at a standstill, and then an attorney had to come in and kind of fight for that. And so think about the relationship you have with that person. It's just like, it's not just about, I love this person, I want to show that I trust them. That's a very different conversation from, I know that I trust them and that they will do what I need them to do when the time comes, because I am not here, and I need to be sure that my heirs, the people who love me, are taken care of. And you are placing the care of your property and your heirs into the hands of this executor. So, not to be all doom and gloom, but this is a really important decision. It should not be made lightly when you are deciding who should step into the role. We do recommend that you should pick one person. One of the goals that we try to avoid when we're putting together these documents is conflict. We don't want people to have conflict about what should we do, what's next, and things along that lines, right? And so we recommend that you select one person, so that way the authority is clear. Who is the final decision maker? If you picked well, you've picked a person who's not going to just be like hand down edicts, right? Like you have a person who's going to be like, if you say, look, I really want to be sure, I want you to be the final decision maker because I need someone that I trust who's going to do what's in the best interest of me, my family, and I need you to sort of turn that role. But please don't do it in isolation. Be sure that if there's questions about, like, the instructions were to sell the house, but maybe one of the heirs wants to live in the house, have conversations with that person to be sure that everyone's interest is being met. And, make sure that you're not just, if someone really wants a family heirloom, that you're just not ignoring them, that you kind of take into account if they say something that I don't know about that they're interested in having, so you want to be sure that you have those types of discussions and conversations with your executor, right? So you're going to empower the one person to make the final decision, because someone needs to make a final decision, but then you're going to give them those conversations so that way when they do have to make those decisions without your instructions, they know exactly what you would want them to do if you were there. And then, of course, you're going to want to have an alternate. I mean, there are times where sometimes the person that's named is unable to serve for various reasons. And so you want to pick a second person who can step into the role, meeting the same criteria, same level of trust, same level of, of instructions and expectations, and have those conversations with them. So that way, in the event the first choice executor is unable to serve, you have someone ready to step into that role to solve against some of these potential problems down the line. All right, so now let's talk about the last will and testament. All right, so what does a will cover? Again, we go in a lot more detail in the other presentation. But to those of you who did watch that, there's going to be some duplication here. But it's important that you understand this before you could even start writing a document, right? So I want to go over this a little bit. It just won't be as detailed as in part one. So again, a plug to go watch part one. But a will covers, it's better to kind of talk about this in the negative first, right? Like, what does it not cover first? So a will does not cover non-probate assets. So remember what I said at the very beginning about the role of the executor. They are the ones who handle the probate process. The probate process is the court process of administering the will and handling the estate. So what that means is that there are some assets that are owned. There are folks in Austin as well as in DC, but our folks in Austin mostly have said, hey, this property is owned in such a way, the way that it's titled, the way that we own it, is owned in a way that it doesn't have to go through the probate process if there's documents in the in place that allows it to avoid the probate process, making them a non-probate asset. And so the majority for most people are financial accounts. So the first three here are financial. Retirement accounts, we're talking about your IRAs, your 401ks, 403bs, whatever those types of financial institution accounts you have. Those are going to be retirement accounts. We'll also have life insurance proceeds. Those are going to be a non-probate asset. And then the third type of financial account is a payable on death account. These are going to be for like your checking accounts, your savings accounts at your regular bank or credit union, where you're going to go and have a payable on death account. For all three of these types of financial accounts, you're going to designate a beneficiary. So you're going to go to the financial institution and you're going to complete a form there that says, how would you like that property to be dispersed upon the passing? And then when the time comes, the heirs will submit a death certificate and whatever documentation that financial institution requires, and that will get submitted to that financial institution, and then they will disperse the property according to the designations of the beneficiary. So it's 100% to spouse, unless spouse passes away, then 50% to the two children. That's what we'll get. That's what will happen. That's what the check will be written, right? So if it's according to their policies of how they disperse the funds. And so one of the things that I always try to make sure I do is to try to give you some tips that, while I do not think that the probate process in the state of Texas is very difficult when you have a well-drafted, properly executed will, and that, again, we're going to talk about how you do that today. If you don't have to go to probate, why go to probate, right? So why have that expense if you don't need that expense? But it is not a difficult process. Please do not be scared of the probate process. Again, we're going to make sure that if you do have to go through a probate process, that this is how we minimize the expense and the difficulties of it, which is a well-drafted, properly executed will. But these will allow you to avoid the probate process for these assets, is these retirement accounts, life insurance proceeds, and payable on death accounts. The fourth type of a non-probate asset is known as a joint tenancy with a right of survivorship. The way that we own property in the state of Texas with other people is that the person you own it with does not automatically get the property. This is a misconception that some people have about property. It's like, well, I own my house with my spouse, so when I die, my spouse will get the property if they're still living. Maybe. That actually may or may not be true, depending on the situation of how your property is owned, how you got the property, and whether or not there's children from a previous relationship, the heirs that would be involved in obtaining the property. So there's actually a lot of different factors that can impact that. And so that's actually not what happens. When you own property with someone else, your property is going to pass according to the law or according to your will. That's actually how it's going to pass. So just because you own it together doesn't mean that the other person gets it. So if you own a house 50-50 with somebody, your 50% ownership of that property is going to pass according to your will, or if you do not have a will, according to the laws. And that may or may not be the person you own the property with. So it's a misconception. A non-probate asset is a joint tenancy with a right of survivorship, which is to make it where that it does not matter what the will says or what the law says, that you now own the property. You have made the property into a joint tenancy with a right of survivorship, where whoever survives in the relationship, in the ownership of that property, is the one who now owns the property afterwards. This is not the default in Texas. This is not what happens naturally. This is not what, you have to affirmatively, which means you must make the property into a joint tenancy with a right of survivorship. You must choose to do that. I do highly recommend that it is something that you are thinking about doing, that you do consult an attorney for that. There can be a lot of unintended consequences of doing something like that. And there's ways to kind of make the same result that don't have the same permanent impacts and then can minimize some potential problems that can arise out of doing a joint tenancy with a right of survivorship. Not saying that you shouldn't do it, but you may want to consult with an attorney just to be sure that we're checking and looking around corners for potential problems that you may not be aware exists because you don't, we look around corners more often than you do in this area of the law type thing, right? So, but that's usually what I kind of recommend. But that is an option. And for some people, that is something they can do with their financial accounts too. So, so let's talk about checking accounts, just kind of going backwards a little bit. You can do a payable on death account. You own the account. You own the account. No one else owns it. But upon your passing, you name a beneficiary, it's going to pass to the beneficiary. And that gives them access to the bank account. With a joint tenancy with a right of survivorship for a bank account, basically you're saying that it's not going to go to the beneficiary. The person I already own the account with is going to be the one who owns the money in the account at that stage. And so that's kind of the distinction. There's no right or wrong. It's just kind of typically that, you know, what works for the household and the financial situation. Right. And so then everything else is a probate asset. That is what's covered by the will. Anything else is going to get covered by the will. Even for any other documents that may exist or things along that lines, it will get covered by the will. What can turn a non-probate asset into a probate asset is if there's no beneficiary listed. So if you have a 401k and you did not list a beneficiary on that 401k, now the estate is the beneficiary of that account. That money is going to get paid into the estate, and then that property will now get passed according to the terms of the will or according to the law if there is no will. And so just kind of keep that in mind. So we do recommend that you're also making sure that as you're updating your documents and everything's correct, that you double check your non-probate assets and that the beneficiaries are still accurately listed the way that you want them to be listed. But just be aware, if you don't put anyone down, it's going to get covered by your will. There are two types of will in the state of Texas, and I covered this because sometimes, even though I'm going to talk about the forms that are available to you, some people want to be able to try to do it in their own handwriting because that's what they need to do. So the two types of will are a holographic will, which is the legal language for a will 100% in your own handwriting. That's all it is. You take out a piece of paper. I recommend a blue pen, a wet ink, and you're going to write down, I, Jesse Campbell, write this as my last will. I give everything to my husband. I name my husband as my executor. In the event of his passing, everything to my children, right? So that's you just sit there and you write it out by hand. This does need to be 100% in your own handwriting. This is not something that can be delegated. You cannot tell somebody, please write in your own handwriting, a handwritten will for me. So it does need to be 100% in your own handwriting. Then it's signed and dated. That's it. That is all that's required to make a handwritten will, a valid will in the state of Texas. Now, doesn't mean that you shouldn't do other things with it. But for some people, if that's the only option they have is to do a handwritten will, they're sitting in a room by themselves and they have no other option. This is a valid will in the state of Texas. It is optional to have two witnesses over the age of 14 who are disinterested. Disinterested means that they have nothing to gain. They are not heirs on the property. They're not owed any money. They don't owe you any money. They basically there's no skin in the game. They're just your neighbor, your friend who's just come to help you witness the will. And so you can have someone that's witnessed, and then there's a self-proving affidavit that's also optional. I'm going to talk about what all this means in a minute after I talk about attested wills. So what is an attested will? So we talked about 100% in your own handwriting. An attested will is, again, just legal language that describes a will that's 100% typed. Whether you take out a typewriter or a computer and you print it out, it's just something that's going to be typed. So that is an attested will. So generally in the state of Texas, the law is written, and I'm about to put a big old exception in a minute, but it has to be either one or the other. It has to be either 100% handwritten or it has to be 100% typed. And so for a typed will, an attested will, it needs to be signed and dated. So you're going to have it printed out. You're going to sign and date it. This one requires, you must have two witnesses over the age of 14 who are disinterested, who witnessed that will. So what does that mean when you witness a will? Is that they're going to watch you sign that will. They're going to be aware that you are signing a will. Like don't have it where they come into your kitchen table and you're like, hey, I'm signing this thing, and they're getting a cup of coffee, and then they sit down, they're like, oh, what is it that you signed? That's not valid, actually, believe it or not. Even though you're afterwards, you're like, oh, that's my will, just sign my will. They need to know that that's what they do, and they need to watch you do it. They need to be able to testify to that when a judge requires them to. And so that is what's required. So if you are sitting at home and you've done a typed will, you bring your neighbors over and they have witnessed the will, and when you sign that will. And that will be a witness. So, and you can do the same thing with a handwritten will. They can watch you sign the will and see that it's in your handwritten will, right? Now, what happens when you have witness wills? Okay, so let's kind of go through the probate process real quickly, just so that you understand what's happening here. With a handwritten will, you're going to go to the judge and you're going to say, Your Honor, here's a handwritten will. Judge is going to say, okay, thank you so much. I see this is a valid will. We need 2 witnesses to come and testify to the handwriting, 2 disinterested witnesses to say, hey, I know this handwriting. I have nothing to gain from this will. I have no skin in the game, but I've seen that handwriting. That can be hard to find, believe it or not, in this day and age. How many people know your handwriting? So that can be a barrier. And so by adding the witnesses to the handwritten will, as well as the required witnesses for a typed will, now you're going to go to the judge and be like, here, Your Honor, here is a witness will. Either way, handwritten or typed, here is a witness will. Judge is going to say, okay, thank you so much. I need 1 of those people to come into court to testify that they did see that it was your will. They did see that you signed it, that you testified to them, that it was their will. And I need 1 of these people to show up and tell me so. Again, sometimes that can be hard to find. Witnesses move, they pass away, they become unavailable for whatever different reasons, right? And so we have 2 so that we hope we find 1, but sometimes it's hard to find the 2. I've had wills that have been executed decades ago, and the witnesses are just unavailable. And so what do you do in that situation? The highly recommended situation is, if you can, you're going to want to use what is known as a self-proving affidavit or a self-proved will, depending on how that will is written. You're going to see in a minute how the pro se forms are written. That's a self-proved will, but you're going to do something where it's self-proving, where you're going to sit down, you're going to sign and date your will. Your witnesses are going to sign and date your will. And then they're going to be doing it in front of a notary. So the notary is going to be watching everyone sign and date wills and realize that everyone's signing a date will. And they're going to notarize it and notarize the will. And that with language of a self-proving affidavit, of an affidavit. And then that is going to be what is admitted into court. And then the judge is going to say, you're going to go like, here, judge, here's a self-proved witness will. And the judge is going to say, great, thank you so much. We're not going to admit this will. No witness is required. Notary not required. So if you have the ability to do a self-proved will, then you should do so. I will say this at the beginning right now, because we are talking about how to do these documents for yourself. Not every notary will notarize a will. So just because, you're not going to be able to go down to the UPS store, they're not going to do it. There's formal requirements to doing a will notarization. And so some notaries just don't feel comfortable doing that, so they won't do that. As part of the AMOS partnership, we actually do have options available to you for notaries to help you do, if you do write your own wills, and Miss Nia will send you all that information as well as part of her email if you do need that assistance. But just kind of be aware of that. All right, well, let's get into the nitty gritty of actually writing this while you're here, right? So first up, we are going to be talking about pro se forms. So what is pro se? That means you're representing yourself. A lawyer is not writing this for you. You're doing it yourself. And so that's what this are. The Texas Supreme Court, that's our Supreme Court here in Austin, has drafted these simple forms. And I need to say that they are simple forms in 4 different kind of categories. A person who is single, widow, divorced, who has children, a married person who has children, person who is single, widow, divorced, who does not have children, and married persons who do not have children. So there's 4 different forms. To the best that I pulled out the overlapping pieces. But just know that depending on the form that you have, the section I may or may not talk about may or may not apply to you. Okay. And the forms are available at that website, but again, Miss Nia will send you the link as well. All right, so can I use this form? I always say buyer beware, right? Just because a form is available, just because you can do something by yourself and there's a document that lets you do it by yourself, doesn't mean it's the right document, and so you want to be sure that you can use that. And so these are simple forms. They may do exactly what you need. They may not, though. So you want to be sure that you're not drafting something that creates more problems down the line, right? The whole point of doing these documents in preparation is to avoid problems. And so you got to think about some potential red and yellow flags about whether or not this is the right path forward for you. What are your family dynamics and your family members? You got to think about that. Who's really going to be able to step in, do what they need to do, the type of property that it's owned. You need to be looking at the type of property you have. Is there things around that we need to be thinking about? Who is inheriting? Do they have special needs that need to be taken into consideration? These documents are not necessarily going to be able to handle those situations. As you have a person living with a disability who's receiving government benefits based on income, an inheritance can impact that benefit, and we would want to be aware of that. Is there a person under a guardianship, so an adult living with a disability who's under a guardianship? There may be some special considerations we need to be thinking about that. A minor under the age of 18, these forms do include what transfer of property to minors, but it doesn't mean that what they have in there is actually what's going to work best for your family and the minor in question. And so it's kind of looking at that. Debt owed. What is the debt that we had? Do we need to be thinking about, you know, secure debt? Is there a mortgage, a reverse mortgage, a car loan? What I don't have in here is there's a possibility that the Medicaid, that we're going to end up under Medicaid, where the Medicaid recovery program becomes something to be taken into consideration. That should be part of our planning. If we think that that's going to be something that's going to come into play as we age, some of us are going to end up using Medicaid for our long-term health care, and we need to be thinking about the possibility of a MERP claim, that Medicaid estate recovery claim that could be happening. So we got to think about those types of things. And then if there's special instructions, are there special instructions? And, because as you see, as we go through these documents, you're not going to be able to put a special instruction in there. So for what's an example of a special instruction? Say that you live in a house and you want the house to be divided equally among your 3 children, but one of your children just replaced the roof. They just took $20,000 out of their own personal funding to be able to help replace the roof, and you want that $20,000 to be reimbursed before the money is split among the children. Well, you're not going to be able to put that in this document necessarily. Maybe, depending on how you do it, maybe you have $20,000 in a bank account that you're going to just be like, okay, $20,000 to reimburse, and then sell the house and split it equally. But what if you don't? What if the asset is the house? That's the inheritance. Well, a special instruction would be, I want the house proceeds to be split equally, but I want the first $20,000 to go to child who, to Susie, who paid for my roof. And so, you kind of want to think about that, right? So those are the things you need to think about. What is it that you're trying to accomplish with these documents? And then write the document that's going to make that happen, whether by yourself, using these forms, or hiring an attorney, or applying for services with an organization like us to help you draft those documents to make that. Don't try to force your estate into this document if this document does not work for you. It's more important to get the document that serves your estate, not the other way around. I know we're all trying to save some money, trying to do things easily, get things in place, but ultimately, at the end of the day, as a lawyer, I'm here to be like, bad news, Jesse. Let's avoid bad news. Let's try to make sure we solve the problems before they happen. All right, let's talk about forms. Okay, the first section of every one of these wills is going to be an identification section, right? Where you're going to say who you are. It's basically what it is, right? You're going to put your full legal name. You're also going to put names that you're known as. You do want to do both, right? If you have changed your name, it may be worthwhile to put in previous names as well. And you're going to do that. And then the second line is basically saying it's your will. You're revoking any prior wills prior to this one. If you're married, this one obviously is for the married one. There's going to be a line for who you're married to. If you're not married and you use that form, there's not going to be a section for you to put a spouse. It'll just say that you are unmarried. And then there's going to be a section, which I don't have the little block, but it's just going to be a little block that's going to be listing all of your children and grandchildren in the next section. And so that's basically, it's pretty easy and straightforward. Oh, I did want to go back real quick, which is to say, remember what I said, that the wills have to be 100% in your own handwriting or 100% typed. And that is the way that the laws are written. This is how the laws are written. That's clear. That's what the statutes say. However, the Supreme Court has said that this form, these pro se forms, can be fill in the blank, that you can take a pen to these fill in the blank papers and it will be considered a valid will. This is the only hybrid will, the only fill in the blank will that I will say is valid in the state of Texas, as far as I am aware. Don't come at me if you're like, Jesse, I saw someplace that said any hybrid will is, I go, as far as I am aware, the way that the laws are written, that it needs to be 100% right, handwritten, or 100% type, with the exception of using these Supreme Court forms. I do recommend, though, that if you have the ability to do so, that you actually type the answers into this will. These are fillable PDFs, so you can type them on your computer and then print them as a printed document and then do the signatures that way. So that way it's 100% typed. That is my recommendation. But that is just obviously information recommendation today. But just be aware that if for some reason you need to do this by hand, this is the only exception to the one or the other. All right. The next section is going to be, and by the way, this can get confusing the way that this can be. So I'm going to do my best to kind of flow through the chart so that way you understand exactly what we're doing. But sometimes but the forms go from most common to specific. So it goes from broad to narrow is how these forms work. So just kind of be aware of that as we're moving through these forms. So the first one is everything that I have, right? Broad, everything that I have. And so this is the form for the married section. It's like, and you're going to have to choose. There's option 1, which is everything to your spouse. And if your spouse does not survive, divided equally among the children. Remember what I said about instructions? This is divided equally among the children or their heirs. So there is no instruction here. This is not an instruction section. This is everything to spouse. If my spouse predeceases me, then everything equally to my children. So that's option 1. If you choose option 1, you're going to sign that box. Okay. Option 2 is you're going to bypass your spouse altogether. Your spouse is not inheriting, right? So this is, even if my spouse survives me, I want everything to go equally to my children. That is what this section is saying, right? So I'm married, but I don't care. Spouse is going to get their own thing. My children are going to inherit everything, and it's going to be divided equally. Now, the thing about this is what it's saying is that it's going to get divided. So say you had 3 children and sadly one of your children has predeceased you, but they have children, then that property is still going to be divided equally into thirds, where 1/3 goes to child 1, 1/3 goes to child 2, and then the 1/3 goes to the deceased child's children. So 1/3, if they have 2 children, 1/3 will be split among their 2 children, each receiving 1/6. They've received their parent's share of the property. So that's how this document is written for how the property is going to get passed. If that's not what you want, then you would need to do something different, right? So, and if you wanted to choose this option, this is the one that you would sign on that document. And by the way, if I go too quickly, please put a question in chat for those of you who are in the Zoom, and I can always go back and repeat. And so now we have the single one. So what happens when you're not married, right? So the single one is you're just going to list who's going to get the property. So again, we're still at the broad. We're still at the everything category right now. So this is everything I own except for something specific. And so when you're single, instead of having it go to your spouse or your children, this is everyone that I wanted to go to. So you're going to list it. It's going to be your cousin. It's going to be your sister, whoever it is, right? You're just going to list that. And if you have 4 people there, they're each going to get 1/4. It's going to be divided equally. So there, again, no instructions here. If you put 3 people, they're each getting 1/3. You put 1 person, they're getting 100%. So that is how that one works for the single folks or unmarried folks. Okay. Oop, I think I just went backwards. Sorry. All right. Now we're in the narrow part. We started at the broad, everything. Now we're in the narrow, the specific. Section 3 is the specific gifts. So this is where you're going to take out the individual items, right? And so the first one, and it's going to kind of go down, right, is your house. So if you want everything but your house to go to, and you can skip this section, by the way, because if you don't have that, if you want everything to be split equally and everything of your spouse, you're going to skip the specific section, right? But so So everything is now going to whoever you named, right, at the top. But you're like, except the house. I want everything to go to Susie, but I want my house to go to Bob. Now you're going to write down here, Bob, right? So that's where you're going to have, and if it's like everything to Susie, but the house, and the house is going to go to Bob and Jane, then you're going to put Bob and Jane are going to inherit the house at 50% each equally, right? So that's how this section works. This very first section that's specifically about the house. It does say here that it's subject to mortgages and lien. All heirs inherit property subject to the debt. And so just kind of be aware of that. Right now, we're going to talk about a transfer on death deed after the will. Just be aware, a transfer on death deed takes priority over a will. So if a TODD has been recorded, transfer on death deed, then that property will pass according to the TODD, not the will. So if you have in this will, Susie gets everything, but the house is going to go to Bob. But then you have a transfer on death deed that gives the house to Susie. Susie's getting the house, even though there's a will that says the house goes to Bob. So we'll repeat this when we talk about the TODD in a little bit, but that's going to be the section on the house. Now we're talking about specific items, again, those narrow individual things for personal and household items. And this one you're going to name all this is all your household items, right? So you have your section where you're just like, okay, everything to my spouse and my children or to these people, but this is the section that I want to go to this is where I want all my personal, this is your clothes, your furniture, your car, right? This is your personal property. Then you're going to list everyone that's going to be split between that, right? So this is the, for your personal property. Okay. If there's any questions about who gets what, the executor is going to serve in the final decision maker in that role, right? So both people really want grandma's favorite coffee mug. Well, executor is going to get to decide who gets grandma's favorite coffee mug. If they cannot mediate that themselves, executor is going to be the final decision maker on this. Okay. Now, how does this relate between the everything and things? You're like, wait a minute, Jesse, that doesn't make any sense to me. What, you just said house and then all of my personal property. That includes everything but the house, right? Yes. So it's possible that you may not even complete section 2 because section 2 is everything, right? So if you want everything to get to one person or two people, whatever it is, you complete section 2, you don't have a specific gift, then you're gonna ignore section 3 completely. Right. But it also could be that you want to split it where everything you own is your house and your personal property. And that's right. That's what most people have. And so you give your house to Bob and then you give your personal property to Susie. Well, you might not complete section 2 because that incorporates everything. Right. So you got to think your way through this and how you wanted to be sure it gets passed. Then the final part of the section 3 on specific is the individual items. So section 2, the one before, right, the one we just did, where it's like, these are the people who are going to split the personal property equally. Grandma's favorite mug, two people want it, executor's going to decide who gets it. Well, this is the section where you say grandma's mug is going to go to Bob, right? So that's where you're going to be like, I know there's going to be a fight over this. I want Bob to get my favorite coffee mug. And so that's what these sections are. So again, we're just getting more narrow. We started with the everything. Everyone's getting something. Then we went to specific, but we went to specific for house and all personal property. And now we're getting into individual items. Grandma's mug, diamond ring, my favorite sweater, right? Like that's the car, right? This is now what we're talking about here, these specific items. You're going to want to be sure you list the items in detail. So that way it's no confusion of what property it is that's being handed over. And then you're going to name the person that's getting the property. If there are people with similar names in my household, every man, I kid you not, 75% of the men in my family are named James and John. And so like, you want to be sure we know which James and John you're talking about, right? So it's, so it's like, we mean James the husband, not James the brother or something like that, right? So sometimes you may need to add a little bit more information in there if there is some similar family names that happen a couple of times. If there's any problems on descriptions and what things look like, again, executor is going to serve as the final decision maker on what happens there. That's it on the property. You see how simple that is, right? Like these are actually pretty simple, but even within those 3 sections, I already kind of identified some potential issues and concerns. So remember, as you're just writing it, you just got to go from biggest to narrow and just know that that's what you're going to do. And sometimes, depending on how your brain works, it may work to work backwards, right? To write down your specific items first and then go up to the section before and be like, okay, now do I want the house and all the personal property to be separated out? Okay, no, I'm going to cross that out, or I'm going to pull that in. And it's like, well, is that everything? Now do I need to cover the second section? Now, that being said, though, I do always recommend that no matter what I just said, you do complete the second section, because there is what is known as the residual estate, things that you don't think about, things that just show up. So remember when I talk about those non-probate assets, what happens to that? That might show up in the residuary, right? Because those are not, like, that could be where you would need to have something identified of who's going to get that property. All right. The next section is section 4. All the wills are the same at this point in time for the next section, which is, the numbers may be different, but the sections are the same, which is naming the independent executor. You're going to name your two choices, your choices here. I told you about two, your first choice and your second choice. You can name a third choice if you wish as well. And this is basically saying who the executor is going to be. They must be 18 years old, and the court must be able to approve them to serve. And so there are some rules about who's allowed to serve. If you have questions about that, you may want to consider consulting an attorney, but for the most part, it needs to be somebody who is bondable and trustworthy. There's some rules about felons that, so if there's a person who has a felony conviction, and they may still be able to serve as the executor, but you may want to talk to an attorney, because there are specific rules around about whether or not a person with a felony conviction is allowed to serve as an executor. That's just an example, right? But for the most part, most people are able to serve as an executor. It's identifying this person to serve independently. So what does this mean? That means the court's not going to supervise the administration. Once the executor is named as the executor, has been given the authority to do the work that they need to do, there's going to be one other event that they have to do with the court, actually two typically, but one required one. And then and that's it. The court, you don't have to go ask the court for permission to sell the house. You don't have to ask the court for permission to, to write a deed, to do whatever that needs to be done. So there's no court oversight. So it makes it independent. This will does not allow for co-executors. So even though I already advised you against, or informed you that you should consider not having more than one person in the same role, this form does not allow it. These will be individual executors serving in the role individually. If the first one cannot serve, then the second one will be asked. If the second one cannot serve, then the third one will be asked. The next section following this is all the standard language around a will. So this is going to be that the executor is going to serve without a bond. What is a bond? It's an insurance policy for all intents and purposes. It's just to protect the estates. And so from mishandling of the funds, if anything along that lines, right? Well, you've picked a person that you trust that's going to be doing what's in the best interest of you. And that's an expense that can be a barrier to someone serving as an executor. So you're just saying, hey, this executor is going to be able to serve without a bond, and so that way, because I trust them. And then it's going to be the powers that the executor has to handle the estate. That's essentially what it is. Distribute the property and pay off the debt. Do what needs to be done to sell the property. And then the next one, again, is talking about the independent executor, where the court is not going to be taking any actions except those required by the law, which is the probating and recording of the will, providing notice to beneficiaries, and the required inventory and appraisement and lists of claims. Again, an attorney is required to do a probate process, so an attorney will help the executor do these required probate proceedings. So for the wills that have children, that for both married and single or unmarried that have children, there is a section related to custodian for people under the age of 21. So it is actually under the age of 21 for property inheritance, is a standard law called the Uniform Transfers to Minor Acts of Texas that basically says that this is how property gets transferred if they're under the age of 21. And that's that the executor is going to name a custodian for the beneficiary to maintain the property until they turn 21. The executor may consider appointing the surviving parent as a custodian, but is not required to do so. It can have different custodians or different beneficiaries. If there's 3 children, it can be 3 different custodians of that, and the executor themselves can serve as the custodian of the property until that child turns 21. So that is basically the provisions on protecting property for children so that they inherit it. Section 6 is naming the person who's going to care for your child or a guardian, an incapacitated adult for whom you are the guardian for. And so this is who you're going to name in that role. And it's going to be first and second choice, and the guardian must be approved by the court, right? So if you have minor children or a disabled adult living in your care, you want to be sure that you've named somebody who can take care of them. So that is what this section is here. The final section is just legal language that's included in a will that says that the Texas law applies. And then there's also a standard survivorship clause for 30 days. So this is standard. If you want more than 30 days, you would need to change that. But basically, it's saying that this is trying to avoid complicated probates. Sometimes, unfortunately, people do pass quickly in time with each other or simultaneously. Car accidents happen, unfortunately, right? And so this is just to try to avoid that, saying that if a person does not survive the 30 days, then the property will pass according to, they will be treated as if though they predeceased, and then the property will pass according to this will, as opposed to passing according to the property of the deceased heir. It's kind of basically what it is. So kind of what happens is that if a person passes, they have to survive 30 days. And then if they pass at 60 days, then the person who passes 60 days, the property will pass according to their will. But if the person passes at day 15, then the property is going to pass according to this person's will, right? So that's kind of how survivorship clause work. It's just intended to protect complicated probates. And then the last section is going to be the execution and attestation. And so this is the witnesses one. Remember, this is a typed will. This is an attested will. This one requires your signature plus the signature of 2 witnesses. Again, so typed, attested. So this is going to be where you're going to print the names here, right? So this first section is printing the names. This is not signing, right? So printing names here are the testator, first and second witness. Again, remember, disinterested, have no reason to gain anything or, appeal for anything under the will. And then this is going to be the actual attestation. This is going to be in the presence of the notary. No one's signing anything without the notary being present. You can complete everything else prior to showing up the notary. I mean, don't sit there at the store doing, filling it out. Fill everything else out. But this part, you must be in front of a notary. So this is you as the testator, the person signing the will, is going to swear to the notary that this is your will, that you're signing it of your own free will, that you're doing this in the presence of the 2 witnesses who are there with you. They're right, remember, because witnesses have to watch this happen. And that you've asked the witnesses to sign the will and that you are now signing it. Then you're going to sign and date it, right? This is now the signing of the will here, right? Oh, I guess I left off the other sections. Then there's going to be another section for the witnesses to sign, and then a section for the notary to sign and affix their stamp with the self-proving affidavit language on there. This one is a 1-step process where it only requires 1 signature by the testator and the 2 witnesses, plus the notary. This is a self-proved will. If you have ever executed another will, sometimes it's a 2-step process where the testator and the witnesses sign and date the will, and then they sign and date the affidavit separately with the notary. But all of this is done in real time in the same space. But in this case, it's only a 1-step process. I bring that up because sometimes people get confused, like, oh no, Jesse, I went to another will where I witnessed and I had to sign it twice. This one is a 1-step process. The law does allow a 1-step process, and that's how this one is set up. And that's it. And again, reminder, not all notaries will execute a will. You can work with us in the Houston area anyways for AMOS for help with notaries if you need that. All right, that's it. That's how you write a will using these forms. Remember, as you're going through this, keep this in mind. You saw how simple that was. Super simple. That may serve your needs. It may not. If you're not sure, please seek out counsel. Don't try to pigeonhole your estate into a document if that document's not going to work for you. And if it's not going to work for you, then consider looking for counsel, looking or drafting your own will separately, using it as a model. But just kind of keep that in mind. But for a lot of people, it does serve their purposes. So, hopefully this helps and you'll be able to do that. So now you've got this will. What do you do with it? You're going to staple the will, like right after you execute it, you're going to staple it, and then you are never going to unstaple it ever again. Taking apart a will can be indication of destruction of the will, and that when you destroy a will, which includes just simply removing the staples sometimes, can be considered voiding the will, and the will is no longer valid. So once you staple it, you're not going to want to do anything else. If you need to make photocopies, don't unstaple it. The recommendation would be make a photocopy of the will before you staple it, and then afterwards just make copies of the copies. Copies are not valid in the state of Texas. There is, not saying that we haven't had situations where we need to admit copies of the will, but technically they're not valid. It's much more complicated. So what you want to be sure is you want to keep your original signed will in a safe space, right? Because what you want to admit to the court is the original will, because it removes all these problems with trying to admit a copy of the will. You're going to let your executor know where that will is so that way it can get it. So where should you put it? Is it your safety deposit box? Maybe. Maybe not. Some things you need to know about safety deposit box. You can only access a safety deposit box if you are, one, an account holder on the account, and two, have a key. It's not enough to just be an account holder. You must also have a key in order to be able to access the safety deposit box. Otherwise, it does require a court order for the court to order the bank to open the safety deposit box, and it can only be open for the executor for the sole purpose of removing the will. So it has to be the executor at that point going in and doing that. So don't put it in the safety deposit box if they're not going to be able to get access to, or just be aware they're going to have to go to court and get a court order in order to be able to do that. That doesn't mean you can't put it in there. A lot of people do. So you can put it in your safety deposit box. You can also, if you wish, file it with the county clerk where you reside for safekeeping. That is also an option. There is an expense associated with that. You do have to pay for that recording, for that safekeeping. That's an option, but not required. I do get asked like, oh, am I required to file it somewhere? No, you're not required to file it somewhere, but you can, and that is an option. And some people do that because it does allow for that safekeeping, and in the event that we can't find the will later on. But again, let your executor know what you've done, right? And let them know. It's like, hey, I filed it with the county clerk and things along that lines, right? So that way they are aware of that. But otherwise, what I recommend, put it with your safe papers. Like where's your social security card? Where's your passport, your birth certificates? Where are all your important papers? I have all of my stuff in a fireproof little safety box in my house. Sorry, I'm not gonna tell you where in my house, but that's where all of our stuff is. And so that way, I live in Houston, hurricanes happen. Like if we need to evacuate, we can just grab our box with all our important papers and then we can go, right? So that's what I've done with ours. But what works for you is what works for you. But you just want to be sure wherever you put it that your executor knows where it is, that they know how to find it, and then remember to remind them they need to do something when the time comes, which is to take that will to a lawyer for them to be able to have a conversation about what the next best steps will be. All right. That's it on the will. We are now about to transition to transfer on death deeds. I typically wait till the end to ask questions, but because of the nature of this presentation, I'll pause for a couple of seconds to see if anyone has any questions about the wills before we move to the transfer on death deed, because it is a different way of thinking about the documents at this point. I want to say this at this point. It's like I talk quickly. This was a lot of information. Here's the good news. You're getting a recording. If you are going to draft your own documents going through this, you can take the recording with the documents in front of you and go through it and practice and do it multiple times. Good news is that until it's signed and executed, it's just a piece of paper. And so you can always shred it and toss it and then work on it. You might want to print it out, put it by hand, and then go and type it into the typable PDF and print it out at that point to get it executed. So those are just some tips to kind of make this process go through a little easier as you are trying to draft these on your own. Okay. All right. Well, with that, let's talk about transfer on death deeds. So this is something that's been passed, has been around in the state of Texas now, I want to say about 12 or so years, maybe a little longer than that, maybe a little less. Let's just ballpark that. But a transfer on death deed is a really great document for a lot of people. For most people, their major assets that they own are their house, their car, and their personal property and their financial accounts. That's going to be their big property. And so and typically what requires a probate proceeding is all of it, right? Like all of the things required that. But if you take care of your financial accounts with either a payable on death account or a joint tenancy with a right of survivorship, all those non-probate assets, you made sure your beneficiaries are listed. Well, now your bank account doesn't have to go through the probate process, right? Your personal property actually doesn't really require, like your furniture and your clothing and things like that, that actually doesn't require you going through a probate process unless there's conflict. Like, right? Like, unless someone needs to step in and make decisions. But if it really is things like, hey, it's going to be a garage sale and the property's going to be dispersed equally, you don't really need an executor necessarily to go to court, get papers to be able to run a garage sale. You may need an executor to come in and get papers to get access to rental property and things along that line. So I don't want to make it sound like there is no need for a will. Everyone needs a will. Everyone needs a will. No matter what is said about transfer on death or non-probate assets, everyone needs a will. Be sure you have a will. I haven't said that enough times today. So, but everyone needs a will. But sometimes you maybe avoid the probate process because the only thing we need to do is a garage sale. And that's taken care of. So those are going to be the big things. For cars and transfer on death deeds, the state has got two documents that you can do for your house and your car. For your house, it's transfer on death deed, which is the property is going to pass according to this document without having to go through the probate process. There's a similar form for a car. We're not going to cover that today, but just be aware there is one for a car, which is a designation of a motor vehicle beneficiary, which does the exact same thing. It's a document that you would complete that says, in the event of my passing, this is who I want to own the property, own the car, and then it passes outside of the probate process. So there is a way to actually completely avoid the probate process depending on your individual situation, but I don't want to say that everyone can avoid it. Again, don't be scared of the probate process. If you have to go through probate, you want a well-executed, properly drafted will, and then the probate process is pretty straightforward. But so when we're talking about the transfer on death deed, commonly known as a TODD, again, it's a deed, like a warranty deed, a quitclaim deed. It's a deed that you're going to prepare and you're going to file during your lifetime. And then upon passing, it is effective immediately upon the registration of the death. And so that is what happens. It avoids the probate process for the home. And that's it. Things to remember, it takes priority over will. Remember I talked about that will at the beginning when we talked about the home, where we said the house was going to go to Susie, but the property was going to go to Susie, but the house was going to go to Bob. But if there's a transfer on death deed giving the house to Susie, Bob doesn't inherit the house. Susie does. And it does not matter what happens in time. You do a transfer on death deed first and then write the will giving the house to Bob. Sorry, Susie's getting the transfer on death deed. You give a will giving the house to Bob, and then you do a transfer on death to Susie, Susie's getting the house, right? Transfer on death deed takes priority over a will all the time, every time. So now the thing is that even though you filed this deed giving this property to Susie upon your passing, it's still your property. You can do whatever you want with it. You can mortgage it, you can repair it, you can rent it, you can sell it. It's yours. But all it is just pre-planning for who's going to inherit the property. If the property is no longer in your ownership at the time of passing, then Susie doesn't get anything. There's no house, right? So just be aware of that. You can only give the portion that you own. So if you own this house 50-50, right? A community property or joint ownership in some way, you can only transfer the property that you own. Community property, that's 50%. Joint owners, the applicable percent, right? If it's 50, if there's two of you, it's 50-50. If it's, if there's some other type of agreement that someone owns 70% of it, then it's whatever, right? Like if it's three people, to third, right? So it's whatever percentage that you own. You can only give what you own. You can't give what another person owns, obviously. Property is still inherited subject to debt. That includes mortgages, reverse mortgages, liens. They continue, they survive after a person's passing, and that whoever's inheriting will need to make arrangements to pay off that debt in whatever form that looks like. So there is a pro se, again, representing yourself, drafting the documents yourself for a transfer on death toolkit. It's prepared by the Texas Access to Justice Commission. It's available on the website of texaslawhelp.org. There's also an online form that you can go through and type in the information, and then at the end it will print out a transfer on death deed for you, and that's that long link right there. Again, all of that information will get emailed to you, so don't feel like you have to take all this notes down real quickly. But today we're going to go through the toolkit. Just know it's the same information. What I tell you need to gather for this form, you're going to gather for if you're going through the online interview process. All right, so the first section of it is you're going to name who owns the property, right? So this is basically you and your co-owner, and you're going to add pages if there's more than one and more than two. You're going to add all the appropriate things. Easy peasy. Who owns it and their mailing address. Then you're going to list the property information is in section 2. There are 2 different categories. 2 is the legal description of the property. This is not your physical or mailing address. Your legal description is not 123 A Street, Houston, Texas. That is not your legal description. Your legal description is going to be the things like lot B, section 4, there's also could be meets and bounds. We're talking about directions, 45 degrees in this direction for 800 feet and things like that. It depends on the property. So what you're going to want to look for to be able to get to get your legal description is the warranty deed. It's going to be the deed that when you receive the property. So you're going to want to look at the warranty deed. I wouldn't necessarily stop there. You may want to check other older documents for previous transfers to be sure that the descriptions continue and they are in line, because sometimes you may need to make some changes and things along that lines, but you are going to want to look for that legal description. If you can't find it, you can look for you can request a copy of your warranty deed from the Harris County, if you're in Harris County, or your county clerk's office. A good place to start if you're going to try to look for it online is with the property description that's on your property tax statement. But remember that box is only like that big. It's not very big. And that might not be the full property legal description either. So don't use your property tax description with that legal description either, because that is probably not sufficient either. So so be sure that that's what you lose. And then number 3, that's your 123 A Street, Houston, Texas address. That is the address of the property, if there actually is one. It could be possible that there isn't a physical address. So that's going to be how you identify the property. All right. So now we're going to kind of get into what can be a weirdly complicated process. And I'm sorry, I every time I do this, I try to think of different ways to describe this to be sure that everyone understands what the requirements are. There's going to be an initial 3 sections, an initial A, B, and C, right? So there's the first level of A, B, and C. You are picking one of the first A, B, or C. So if you pick A right now, you're not going to pick a B and a C later. Okay. So this A is when both spouses own the property and they want to leave it to the surviving spouse. So you and spouse own property and you want your surviving spouse to get the property. Then you're going to complete section A. All right. Then, so that's what number 1 says. A1 says primary beneficiary is surviving spouse. A2 is listing the alternate beneficiary, and this is going to inherit the property when both spouses pass, right? So this is what's happening. It's like, so this would be pretty typical when it's spouse and children are the children of both spouses, right? So this would be a typical thing. Not, again, we're not saying, individual plans. I'm not saying to do this. I'm just saying that this would be a typical type of thing where you're married to your spouse, you and your spouse, all your children are the same children. There's no children from previous relationships or either one of you. And so it's like, okay, spouse is going to inherit the property upon the passing of the surviving spouse. Now the property is going to go to these alternate beneficiaries, which may or may not be your children, right? And so then you're going to list that, and then they're going to inherit the property equally. If you have more than 2 beneficiaries, you're going to add pages to it. Okay, but they, again, inherit equally. If there's 2, 50%. If there's 1, 100%, 3, a third each. All right, so that's going to be section A. Section B is when one spouse owns the property and wants to leave it to the surviving spouse. So Section A, you both own the property. It's community property or joint ownership. Section B is you are married, but you own the property. It's separate property, right? So you're not going to pick A if you're single and you own or if you're married and you own your property separately. You're going to pick B, right? And so B, you're going to name your spouse as the primary beneficiary, right? So that's what B1 is. You're going to name your spouse. All right. But here's a key thing. Under A, the children inherit, or the alternate beneficiaries inherit on the passing of the surviving spouse. That is not what happens in B. In B, the spouse is the heir. The only time that the alternate beneficiaries inherit the property is if the spouse predeceases. So in this case, the property is going to go to the surviving spouse, but only if the spouse passes before the property owner, then it will go to the alternate beneficiaries. So if you want the property to ultimately go to the children, you're not going to pick B, because B will make it that the property ultimately goes to the spouse and their heir, not the children. So that's what B is. That's you own the property by yourself. All right. So again, this gets complicated. Please don't complete all of them. Remember, you're picking A or B. Okay. For both A and B, we're going to get to C in a minute because C gets complicated. So for both A and B, beyond the alternate beneficiary. So what happens if the alternate beneficiary, we now have gotten to the alternate beneficiary, who's going to inherit the property when things happen to the alternate beneficiary, right? And so if it's a child or a sibling, then you're going to make a decision, right? It's like, I want that, if that child should pass before I do, 3A would be that it's going to go to that child's heirs, right? That's what it's going to be. So if you pick 3A, you have 2 children, 1 child passes, they have 2 children. That 50% that was going to go to the child that passed goes to their 2 children equally, right? So that's what happens when you pick A. If you pick B, you're saying no. You're going to say, no one else. I don't want it to go to the deceased child's heirs. I want it to go to the surviving alternate beneficiary. So if you pick 2, you have 2 children listed, 1 passed, even though they have children, it's going to go 100% to the surviving beneficiary. So that's what B does. Okay. And then if there is no surviving beneficiary, so both of them, you listed 2 children, sadly, both children have passed, even though they have children, you're saying if you pick B, no one else gets the property. And now it's going to pass according to your will, which is, again, why you always need a will, right? It's going to be like the transfer on death deed never existed. Okay. All right. So that is for A and B. You're going to complete the 1, 2, and then you're going to have a 3, and the 3 looks exactly the same for A and B. All right. Remember, we're still in the choose one, A, B, or C. Now we're in C. C is everything else. If A doesn't apply to you, you're not married, or you don't want it to go to your surviving spouse and then your children. B doesn't apply to you, you're married, but it's your separate property and you don't want it to go to your spouse, etc. Then you're going to pick C. So now you're going to pick this C. So this is everyone else, but your spouse is not a primary beneficiary. You can make them a primary beneficiary in this case, but they are not. It's not the default. The default for spouse is going to only be A and B. So under C, you're going to list who it's going to be, who are going to be your primary beneficiaries, right? And it's going to be, you can pick up to 2. If you want more than that, then you're going to add a separate page. Then you're going to list your alternate beneficiaries, right? And so again, alternate beneficiaries only inherit if the primary beneficiaries pass before and they don't inherit. So that's what it's going to be. Okay. Oop. Now, if you have selected C, then you must complete all of A, B, and C under that C, right? So we've picked either A or B or C. If you picked A, you're done. If you pick B, you're done. And you're going to do the 1, 2, and 3 under each of those. If you pick C, now there's another set of A, B's, and C's under that. And you must pick one for each of those because each one of them is going to build off of a situation that exists from before. If A exists and then B exists and then C exists, right? Like we're trying to avoid having to go through a probate process. That's kind of what's happening here. We're not trying to think about what do you want to happen in each of these situations. All right. So we're going to pick A if at least one primary beneficiary survives me. So that's A. So you've list. So for all purposes now, we're going to assume two. Bob and Susie are inheriting the property at the first level. All right. So Bob and Susie. So Bob and Susie are your primary beneficiary. What happens if either Bob or Susie passes away before the testator does, before the person passing on the property, right? If you choose A, it will pass to their children. So if Susie should be deceased, her children will inherit the property. Her children will get the 50% that belong to her. So that is what happens there, right? And then Bob gets his 50%. That's if you choose A. Sounds familiar, right? It's the same. It's the same thing as under the three that I just talked about. Then B, no one else. If Susie doesn't survive, doesn't matter that she has children, Bob is going to get 100% of the property. Okay. So no one else. Okay. Now, so that's A. Then there's B. You still have to do this. I know it seems like, wait, does this really apply? Yes, it does. You still need to do B, the CB. What if no primary beneficiary survives me, right? So Susie and Bob have been listed as the primary beneficiary. So if you pick A, under A, Susie pass, 50-50. You pick B, Susie passes, 100% to Bob. We're done. That's it. It stops there. There's no situation there because Bob has survived. He gets 100% of the property. Or it's 50-50. We're done. What happens if both Susie and Bob should pass before? That's what section B is, right? Now it becomes a who gets that. If you pick A, just like the other A's, their heirs get their half. Susie has 2 children. Those 2 grandchildren get her 50%. Bob has 1 child. Bob's child gets that 150%, right? So now we have 3 grandchildren. 2 of them are going to get a 25%. One's going to get 50% because they're going to get their parents' share of the property. That is what A is saying, hey, if that doesn't happen, then it's going to go to their heirs. B is your alternate beneficiary. So I'm going to go backwards now, right? So if you see, I'm not pointing at it like you can see me pointing at it, but you can see under C, there's the primary beneficiaries where you're going to list Bob and Susie, right? Now, if you go back down, you'll see under B that if Bob and Susie should not pass and you pick BA, their children will inherit. But under 2, you have your alternate beneficiaries. This is where you're going to put Nathan and Joanna. I've got new people now. Nathan and Joanna are now your alternate beneficiaries. If you were to choose BB, then you're saying, does not matter that Susie and Bob have children. If both of them should decease me, then I wanted to go to Nathan and Joanna. That's what choosing BB means. All right. So that's what that is. I know that's why I say go watch the recording. All right.
This is Zoom.
Oh yeah. So it's what happened if it doesn't let you go inside?
Okay. All right. So now we're going to the next section for C. You still have to do all of these, right? So now what happens if Nathan and Joanna don't survive, right? Then what are you going to choose there? So, right. So A, we assume at least one person survives of my primary. B, we assume both don't survive. Both of my primaries don't survive, or all of my primaries don't survive. Who do we want to go to that? And then C is if the alternates don't survive. So by the way, though, if the primary should pass, even if you pick A, right, if both Bob and Susie had no children, then it's going to go to the alternates because there's no heirs, right? So then C is what happens if Nathan and Joanna don't survive. One or both don't survive. And that's where it's going to be. If you choose A, you want Nathan's children to get their heir, Joanna's get their share. And if both, and then C, that final one, No one else. If there's no survivors, then this transfer on death deed never existed. So you do have to do all three, because we got to plan for all of these scenarios, because remember, lawyers are kind of like bad news Jesse. We're trying to solve problems before they happen. These are problems that happen. So that is what those sections are. You just got to read through it carefully. It tells you exactly what each of them does. But again, if you have questions about it, please seek out counsel, because, once these are filed, you have to change them. You have to affirmatively do something to revoke them in order to be able to make that correction. Okay. All right. I do see the questions. I will get to them when I'm done going through the forms. Just FYI, everyone. All right. So what to do next? So with a notary present, you're going to sign the TOD with the co-owner if applicable, right? So if you pick section A, right, surviving spouse, both owners are going to sign the property. And then the notary will sign and affix the notary seal. Typically, a lot of notaries will sign transfer on death deeds. I haven't heard of anyone not choosing to do it, but if you're going to go and work with somebody who can sign a will, because again, everyone needs a will, you might as well go ahead and get the same notary, do your transfer on death deed at the same time, and then you got all your bases covered. You must record the TOD. What does that mean? You must file it. You must actually send it to the county clerk's office where you are residing and file it. There is a cost associated with that, depending on how many pages that transfer on death deed. In Harris County, you're probably looking between $30 to $40 for filing, but it does depend on the county where you reside. Don't ask me how much it is in, Polk County. It could be a completely different price there. But you must file it. It is not valid unless it is filed. So just be aware of that. Once it's recorded, the clerk will return the TOD back to you. So you'll have a recorded copy with the stamp on it saying when it was recorded, and then you're going to keep it in a safe space along with your will and other advanced planning documents. Remember, I've said this a couple of times that a TOD is going to take priority over a will. And so if you change your mind, you must do something. You must actually take some action with the TOD. You must either do a new TOD to revoke that. Effectively, when you file a new TOD, that automatically revokes an older TOD. Just like if you sell the house, it automatically revokes the TOD. So you either need to do that, or if you want the property to pass according to your will instead, because again, that TOD's going to take priority over a will. If you wanted to go according to your will instead, then you're going to want to be sure that you file a revocation, an actual revocation that also needs to get filed. And so some people will make some decisions about whether or not they want to go with a TOD versus a will or things along that lines. I'm going to let you know, though, that there are times where TOD is not where you want to go, right? Just the same thing when I'm talking about using those simple wills, where you got to take into account those individual dynamics. That applies to the TOD too. Who's inheriting the property? Is there debt we need to be considering about? Do we have to worry about benefits? Like, are there minors that are going to be inheriting the property? All of those factors are going to impact whether or not you should use a TOD as well. And so you want to be sure that you're taking that into account. Don't use these documents blindly. Don't force your estate into a form. Use the document that's right for your estate and what your needs are. And so just because I told you this is an option and you're like, if your primary concern is to avoid probate, again, a property drafted, properly executed will is going to make that probate process easier. And in fact, depending on your situation, that might be the thing that is the least expensive process, the least problematic than doing something that isn't the right thing to do. So to the best of my ability, I am going to encourage you, if you can seek out counsel to be sure that your documents work for you and do what you need them to do for you, rather than trying to do something just because it's easy. We may create problems for your heirs down the line. Okay, so all right, I'm going to go back and answer a couple of these questions that I see. The harder one is the as it relates to there's scams out there, right? People are stealing property via deeds, and that is something that is unfortunately happening. There's a lot of things that you need to kind of be mindful of. Don't ignore letters, don't ignore emails that look like they're suspicious. I mean, most times government officials will will send you a letter about things, but you want to take those seriously if you see something that looks out of place, right? And the scams just kind of get worse as they go. But yes, properties can get stolen not pretty easily. I mean, but they do happen, right? So you do want to be vigilant along that lines. this is public record, right? Like, but not everyone can have public access to it, right? So, in order for me to get access to public records, I'm an attorney. I have to submit my bar number and things along that lines, but you can go down to the courthouse and request copies of public records in that way. But a lot of this information is available pretty easily on the website. And a lot of the things that you need to do to protect yourself is just to be vigilant about what's going on, right? Like every so often, like, if all of a sudden you notice that you didn't get a property tax bill, that's a clue. Right, right, like that something's going on with your property, that you are expecting a property tax bill and you didn't get. Be careful of who you give power of attorneys to. We're gonna talk about other forms in a minute, but I do talk about, again, like when you give those power of attorneys for people who are able to do things like that, those are ways to ensure that you can do, don't sign things blindly. Never sign anything blindly. You want to be sure that you're reading it. If you're not sure what you're reading, go seek out an attorney. And anyone who's telling you, it's a super red flag that when you say, I want to talk to an attorney about this before I sign it, and then they're like, well, you don't really need to. Don't you trust me? That's a super red flag. Don't trust that. So it's, but unfortunately, I don't have strong answers for that. But to answer your question, yes, a lot of this information is public. It doesn't necessarily mean it's easy to get, but it doesn't mean it's impossible to get. But you got to just be vigilant of things that look suspicious and follow up with them as soon as you can. The other question was about how do you get your legal description? You should have a copy of your own warranty deed from when you purchased your property. You can pretty legitimately use the description that's in that warranty deed that you had to be able to do that. Now, if you got your property not through a sale, like you inherited it and came in by a deed, a gift deed or a quitclaim deed or things along that line, that property deed description probably is not sufficient. And so you're going to want to dig a little more deeply into that. That may be something that you may need some assistance with, either a title company or an attorney to help you find that legal description. But no, the information on HCAD is not going to be sufficient because HCAD shortens those legal property descriptions in order to fit the space of their pieces of paper that they use for their property. I have seen legal property descriptions be as long as a page, a full 8.5 by 11 page legal description. So you want to go look at the actual deed when you inherited when you got your property. The warranty deed is likely, again, if you used a title company and things like that when you purchase your property, that legal description is probably sufficient. But if you got it through something else, like someone gave you a quitclaim deed or someone wrote something that wasn't done by a realtor or an attorney or something, then you may want to dig a little deeper into going into further documents, or whoever transferred the property originally, like do they have a warranty deed, and then kind of go backwards to try to correct the deed.
Jesse, do you happen to have a copy of what the full legal description looks like, or do we want me to go online real quick to see if I can find one so that people can know the difference, like what they see on a tax bill versus what's actually kind of required, or an example of what's.
I don't have one that I can pull up real quickly.
Okay.
But they vary greatly. They right, like sometimes they match, which is why it's hard, right? Sometimes the HCAD description matches because it's that short, but sometimes they're not, right? And obviously anything I can go find will be someone's real legal description. So we would have to create a fake one, right? So we don't want to like put someone's real property description online somewhere.
Let me look at Lisa's presentation, because I know that I think she had like a page that had an example,
like a fake
of
one.
So let me see if I can find one real quick.
Yeah.
But go ahead and finish.
I can't do it because I got to fake one up, bro. So, but yeah, you're gonna want to look at the actual deed. I see that. I think I saw that. Yeah, I think Nia said that. Okay. So that is it on transfer on death deeds. We are actually almost done. The next slide is that there are additional forms. We're not covering any of these additional forms today. Please go back and watch that video from last month, or come to the one next month, because I alternate every other month. But there are some additional forms that are part of the estate planning. A will and a transfer on death deed are not it. That's not the end of the game. You do have some documents, statutory forms for planning for incapacity. Include the statutory durable power of attorney, medical power of attorney, advanced directives to physician, also known as a living will. That is a document for end of life planning. in the event of a terminal or irreversible conditions. There's also for those who are at risk for psychiatric hospitalizations, there is a directive for a declaration for mental health treatment that you can also complete. This is obviously very individual for people who need that particular document. Some additional documents that you may want to have in place is a declaration for a guardian in the event of later incapacity, a HIPAA release, a supported decision-making document that's for people with diminishing capacity. They're not incapacitated yet, but sometimes they may have some difficulties understanding things, and they need some support to make those decisions. That's what this document kind of helps identify the person who does that. I realized I did not include the designation of a motor vehicle beneficiary that I talked about. There's that document, but please go watch that other video where I do talk about all those other documents and what they do. But those forms can also be completed on their own. They're a lot more straightforward than the will and the transfer on death deed. So that's why I don't spend a lot of time talking about them, because when you look at them, it really is just about completing the form. You're just reading it and then selecting what you want, very similarly to a fill in the blank kind of form. But the other session does talk about what each of them does more specifically. Right, I think I saw another question. Ah, okay. So that is it on that. That was a lot. That was a lot of information. And I know, don't be overwhelmed by this. We are here to help those of you who are eligible for assistance. If you believe that you may qualify, and as much as 30% of the state of Texas qualifies for legal aid services. So don't assume that you don't qualify for services. But that's my contact information. It's also right here. That's my phone number and website. You can go online if you are comfortable going on the computer. There's an online application. Just say that you need a will, and that's going to come to me. And then I will be able to look for a volunteer attorney to help you do those documents. I will be the one who will do the assessment and everything. But you can also call either our Houston number, which is that 713 number, or if you're outside the Houston area, the 800 number serves our entire 72 plus 74, plus our 4 counties in Arkansas. If you are a person outside of Houston who needs assistance, that may or may not come to me, but it may come to me. And so that is kind of how you can apply for assistance. I do see the question, how can you avoid probate altogether? I cannot answer that question because it's a hypothetical at this point in time. It does so much depend on your individual situation and your individual property and your individual needs. And then what happens at the time of passing. Sometimes you can do the best that you can to avoid the probate process, but then at the time of passing, the situation of what's going on with the estate and the property and the debt or whatever requires a probate, even through our best efforts. So no, I can't, any lawyer who tells you that you can 100% guarantee avoidance of probate is not telling you the truth. We can't guarantee that, but depending on your situation, you may be able to limit the need for a probate through using transfer on death documents, making sure your non-probate assets have beneficiaries listed, making sure that you have a payable on death account for your financial accounts, for your checking and savings account, and or having a joint tenancy with a right of survivorship for those financial accounts, and then using a motor vehicle designation. But no matter what, regardless of what I said, you still need to have a well-drafted, properly executed will in order to minimize the impact that a probate may be if a probate is required. In terms of recommendations to beneficiaries living in another state, it doesn't really matter beneficiaries can live in other states and they can inherit, right? It's just a question of being sure that they have access to the information and things along that lines. There may be complications around, like if they need to sell property or come in and do things like that, but that's just something for the executor to kind of take care of it. But if they're inheriting the property via TODD, you're not required to live in the state of Texas to own property in the state of Texas. That's not a thing. You can live in California and own a house in Texas, and so you can still do that and without any real concerns. I don't recommend though that you pick an executor who lives outside the state. It's possible you can pick an executor outside the state. It just adds more complications and a little bit more difficulty. So if there's an executor in the state of Texas, that's better, but not if you don't have someone in Texas, that's fine. Pick someone in California. That's okay. The lawyer can figure it out.
Okay. There were a couple of other...
my cartoon and questions.
Oh, okay. Thank you.
I like always another funny, but we have plenty of time for questions. So if people have questions, but I didn't change to my summer slide yet. You get my summer slide in June, but it's May. There's still snow some places in the up north of us, but it says Mr. Frosty, it's March, time to talk estate planning. But we know that's not true because when the magic cat comes back, Mr. Frosty returns. For any kids watching. Let's hope there's no kids watching. Any questions from anyone? Feel free to unmute yourself. Nia's going to go look at for those of you watching live on the live stream, either on Facebook or YouTube, she's going to ask me the questions. But those of you, if you're on the Zoom, if you prefer to unmute yourself and ask your questions, feel free.
Before I interrupt anybody that has any questions here. Okay, you answered the one about the beneficiary living out of state. Okay, got that. All right, here's another one that was emailed to me prior to. My interest is knowing how to set my home up so that there are no back taxes for my survivors. Since I pay no taxes, I am tax exempt. That's a little bit outside the scope. However,
The scope. Unfortunately, I don't think I can answer that question the way that they want me to be able to answer that question because I need more information because it does depend. It kind of depends on what's going on. But typically, and Nia, you can probably answer this question probably better than I can, quickly anyways, the taxes are still going to get owed, right? If it's a deferment, the taxes are going to get owed. If it's an exemption, then there's no taxes owed, right? So we would need to know if it actually is an exemption versus a deferment.
That's the biggest thing that we talk about in the property tax workshop, is to know the difference between the exemptions and the deferral. So if it's deferred, the property taxes will be owed 180 days, no later than 180 days after the person passes. If it's an exemption, the taxes are not owed. They don't pay that money back. So if you are exempt from property taxes, then they will still be exempt up until the time you pass. Somebody had asked a question about reverse mortgage. I saw one on here, reverse mortgage. What happens if the ownership of the home when there is a reverse mortgage?
The ownership still passes. So according to the will and or the TODD, or the TODD, not and or, it's one or the other, or the TODD, right? So the ownerships will still pass. But things to keep in mind, they inherit the property subject to that reverse mortgage. Reverse mortgages, for those of you who are unaware, if you have one, that they are due 6 months from the date of death of the person who took out the mortgage. That's a very, very short amount of time. I know it sounds like it's not. It is. It's a very short amount of time for that heir or that executor to figure out what they need to do. It does depend on the situation, on whether or not you want to do things via a will versus doing things via a TODD. And that one, I would probably recommend you talk to somebody to know what would be the best way to do that. A TODD is faster because they obviously own the property immediately upon the recording of the death, and that gives them the full 6 months to either sell the property or come up with the financing that they need to pay off the reverse mortgage within that 6 months. So it's a little less time. On average, most probates start between 3 to 4 months after the person's passing. So it's not so if you wait until then the executor only has that 2 months to make those arrangements. Most reverse mortgages companies may provide you a little bit of extra time, but it's typically not. And some of them are pretty hardcore and they give you no time. Or if they allow you to do a refinancing, it tends to be not in the best terms for the heir. But I don't speak for mortgage companies. No one come at me, but you want to give your people as much time as can. But just be aware they do have to pay that off in some way, either by paying it off or financing it to pay off the reverse mortgage in order to inherit. Otherwise, they will foreclose.
Yeah, and then I definitely would recommend that you reach out if you know that there is a reverse mortgage on it, that that you get permission to even speak to the mortgage company about what's going on, on the mortgage. Have them add your name as that person of interest for them to talk to. The second thing is that if there is a reverse mortgage on it, that you actually have to request that extension if you need longer than that 6 months. It's not going to be automatic. They will start the foreclosure process after that 6 months if you haven't made any kind of arrangements or attempt to communicate with them whatsoever. So definitely do that. We did do a reverse mortgage presentation back in March. That is going to be available on the AMOS Houston YouTube channel. So I will include the link for the YouTube page for you guys to go back and watch that if you needed more specific questions. That presentation was done by a reverse mortgage, or what they call HECM counselor. And she did that presentation in addition to Lone Star Legal Aid also did a reverse mortgage or mortgage foreclosure prevention presentation for us too, so that you'll know what the legal process is if you find yourself, facing foreclosure because of a reverse mortgage. So go back and watch that presentation as well. So that is available on the website. For the folks that had the question about the taxes, we do a property tax workshop the fourth Wednesday. Yeah, the fourth Wednesday of each month. However, because the protest tax deadline is coming up um, on May the 15th, we're going to be doing our presentation on May the 14th. So if you have additional questions or want more information about the property taxes and how the deferrals versus the exemptions actually work, then come back and watch that presentation on May the 14th. But the previous workshops about property taxes is also available on the AMOS YouTube channel that you can go back and watch as well. So, and I will be providing that. The link that I put into the chat for you guys about the transfer on death deed available on the Texas Law Help website. That link will be included in the email that I send out to everybody that have registered for this presentation. So the recording will also be included. So if you guys want to go back and watch it and kind of take a look, a copy of the Transfer on Death Deed Toolkit will be made available along with the link for the will form that Jesse went over will be included there as well. So if you want to kind of look at it and follow along with the presentation, then definitely go back and kind of view and watch at the same time as you're looking over those documents. So sometimes it's a little bit confusing if you're trying to look at the documents and then listen to at the same time. So I send them afterwards. So that way you can go back and look and actually have a physical copy in front of you or have something in front of you to actually look at. So I wanted you guys to focus on what she was actually saying versus trying to write those kind of notes and then listen at the same time. It does get a little bit confusing trying to flip through all those pages, but just know that I will be sending out a copy of that for you guys to look at as well. So those were the main two questions that were emailed, and I don't see anything on the social media pages. So I do believe that is it. Somebody started a question and then they cut it off. So I didn't. Oh, you know what I did want to ask you, Jesse? And I thought about this when I saw this question. It would probably be a good idea for us to do a presentation. I don't know if you got someone in your office and we can talk about offline about protecting your business assets when you pass. Like, how does that work? Because we had a young lady that was on a couple of months ago in the inherited property presentation. Her dad had a business, a small business, and she didn't know what to do with his business assets, what happens to the company and the business property and all of that kinds of stuff. So that would be a good one for us to have. But that was a question that somebody actually had too about the personal property versus business property and how they protect it and how is it different.
Yeah, no, those are distinctive, and it does depend on how that business is owned and how it's like that can get complicated. So yeah, beyond like succession planning. Yeah. So no, let's talk about that. But I think that might be a good thing to add. Mhm.
Okay. Let's see. I do believe that is it. Uh,
It's early for those of you who we get
okay,
people
you're
who
welcome,
are
Miss
50. I
Cheryl.
normally go right to the 2 hours, so we're early. I'm giving you 15 minutes back, everyone.
Yeah, that's a rarity. Well, that's because it's not as intense as the other one or as much detail as the other one. So yeah, we finished a little bit early. Again, we alternate between this one and the legal advanced planning and why do you need it? That's kind of like the part one. This will be the part two. Part three will be next Thursday, the second Thursday of each month, about inherited property, what happens after someone passes, what that probate process is actually like, and how to address those concerns if there are deferred property taxes. If you do have to pay that bill, what's those payment options like and how to avoid that foreclosure and all of that kinds of stuff. So we do talk about that next Thursday. So definitely want to join in for that session as well. And we had to divide these things up because when we only used to do this one presentation about, the wills and estate plan, and then it kind of led over to others and others and others only because of the feedback that we received from you guys. So at the end of this presentation, there will be a link kind of asking, would you think, how, was there more information that you needed? Are there other questions that you have? Are there other presentations that you want? Please provide us with your feedback so that we'll know how to plan ahead moving forward as far as what it is that we need to bring to the community or let you guys know about. So if there are other pertinent issues or something that's facing you guys' community, then please reach out to us and let us know. So again, so that we'll know how to plan or what to provide. Case in point, that question about the business property taxes and property after someone passes, what happens there? So that's a great idea for us to look into providing for you guys. So we want to thank you all very much for coming. Yes.
I did want to recommend that even if your primary reasons for coming to my 2 sessions is to learn about your planning, writing your estate planning documents, I do recommend you still consider attending the what happens afterwards, the probate or declaring title one, because understanding the probate process and what happens when there isn't a will or what needs to happen does actually help you draft the documents at the beginning. So when I talk about those like yellows and red flags, that session is going to talk about some of those problems that come up, and that can help you draft your documents better in anticipation for it. So do still consider attending that one. Okay. All right.
In addition to talking about having the conversation, people just really kind of need to get back to having conversations about this kind of thing. And we know that a lot of folks in a lot of those communities just don't want to talk about it, as if it's not going to happen. It's inevitable. It's going to happen to everybody. So we just kind of trying to, take some preemptive measures to I'm not gonna say lessen the blow, but make it as easy as possible for your heirs moving forward, so that they're not trying to grieve and then still try to handle all of that stuff all at the same time, because it's very cumbersome, it's very stressful, it's very time consuming to try to figure this kinds of stuff out after someone has actually passed. So so the idea or the thought process behind this is also to make sure that you plan ahead and make it as simple as possible and protect the assets that you guys have and what you've built, what you've already worked for, to make sure that it does get passed along, so that it is not lost, and is protected, and your family is secure. So with that being said, thank y'all very much. I will get off my soapbox about this too. So thank y'all very much for joining us this afternoon. We do hope that you did find the information to be beneficial. Again, please provide us with your feedback and let us know if you guys got what you needed. So if there's any additional questions, the contact information for myself will be sent out to you guys as well, along with how to apply for the services with Lone Star Legal Aid. The link will be provided on the email that I send out. So we want to thank y'all very much. And hopefully we'll see you guys next Thursday for the inherited property presentation and what happens after the probate process. So thank y'all very much. You all have a wonderful day. Take care of yourselves and stay safe. And we will see y'all next time.